The standard, the Web Content Accessibility Guidelines, version 2.1, levels A and AA. What does that mean? The WCAG exists in multiple versions. The most current version is 2.2, but the requirement is 2.1. Levels A and AA, not AAA. A are basic requirements. AA are considered the standard requirements. AAA is considered aspirational. And the next slide, as you can see, there are exceptions to this obligation to make covered web and mobile app content accessible for what changes may be considered or what accessibility may be considered a fundamental alteration of the nature of the program's services and activities, or what would cause an undue financial or administrative burden. Okay, so the requirement is WCAG 2.1, A and AA conformant, unless these exceptions apply. Significantly, the covered entity has the burden of proof to show at trial that these covered defenses apply. So it has to show facts, rationale, support for the position that not making something that would be covered is not WCAG conforming, that would be an undue financial and administrative burden, or it would fundamentally alter the nature of what government benefits, access, programs, and activities are being offered. And this is the same exceptions generally that's what's originally incorporated into ADA Title II. Okay, so it's generally consistent. Now, if you claim the benefit of that exception, there's a limitation on that, and that's what's at the bottom of this slide. You still have to the maximum extent possible, make the web content accessible. And so, for example, let's say that you have a web page with a map functionality or a map feature, and the map feature is provided by a third party, and you take the position that that cannot be made accessible because it's an undue burden or it's a fundamental alteration. That doesn't get you off the hook necessarily to make other aspects of that page accessible to the WCAG 2.1 A and AA standard. Okay, so you have to comply to the maximum extent you can, but except for these defenses.